following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the intricacies of the Gender Equality Bill and its developments. What does the future of equality look like in Sri Lanka, and how do recent judicial decisions shape this landscape? A very good evening, and thank you for taking the time to join us on yet another episode of Law, Land and Liberty, where we'll be breaking down key legal concepts for the layman. Now, today's topic is something that is still developing in real time, and that's on the Gender Equality Bill. We saw some recent determinations as well come forward in the current context and how it's actually impacting other legislature as well. To speak about the Gender Equality Bill and its intricacies and what the current situation looks like right now, we have someone that is well suited for this program, and that is Major Charitha Siriwardene, attorney at law. Sir, thank you very much for taking the time to speak to us today. Sir, before we go into the program, a little bit of an introduction on our guest. He is a retired army officer. If you would have heard me recall, he's Major Charitha Siriwardene, one of the first of our kind to go on our program as well. He's practicing as an attorney at law and is appearing as a counsel at the Supreme Court and the Court of Appeal, as well as other courts. Safe to say we'll be in good hands when it comes to the discussion of the intricacies of this topic. Now, before we go in for the program, this is a breakdown of how we're going to approach it. First, we'll be talking about the fundamentals. What is the Gender Equality Bill and where is it right now? Next, we'll be talking about the determination from the Supreme Court and also the current evolution of the bill. Finally, we'll be talking about the overall impact that this bill has on Sri Lankan legislature.
I'm Dilshan Kalhara. I'm a student at Sri Lanka Law College. My question is on the Gender Equality Bill. What are the salient features of this bill?
All right, well, we have quite a lot to break down on today's topic. So once again, thank you very much for taking the time. We have a lot to unpack relating to this, especially with the recent developments. Before we go into any current specifics, could you please give us a little bit of an overall understanding of what the Gender Equality Bill really is?
Actually, in our constitution, gender identity and gender equality is not recognized. What the proponents of this bill want to do is to introduce, gender also into the Sri Lankan law. As far as our laws are concerned, that is the constitution and other laws made thereunder, sex is male and female. That's all. Now, gender is more than the male sex and the female. It is whether you are male, whether you are female, or whether you are both, or whether you are neither. Something like that. So that is not recognized in our constitution. Now, if that is recognized, it can give way to homosexuality also, because the homosexuals are their conduct is neither male nor female. It is a kind of sexual orientation. So sexual orientation is bang on gender identity. So with that sexual orientation, they can be identified as per the gender. So then, as per this bill, if it becomes law, homosexuality will be all right, lesbians. Not only that, then marriage between same sex and transgender. Now these things are taboo in our present society. So all those things will become law. So that is the idea behind the Gender Equality Bill. They want to legalize what I said, gender identity and gender equality.
Apart from that premise, sir, what are the other key provisions that we see stand out to you in relation to this bill?
Actually, now when you consider this bill, you know there was a determination regarding this lately, maybe a few days ago, by the Supreme Court. There it was held that this violates the right to equality. I beg your pardon, not the right to equality. That is Article 12(1) of the Constitution. Just may I read it out to you? So that the people will have a good idea. Article 12(1) is, all persons are equal before the law and are entitled to the equal protection of the law. So now, that means, as per this article, it gives protection to the children of this country. The parents depend on this article. You know, under that, we can find sections 365 and 365A of the Penal Code. That prohibits, you know, unnatural sexual acts against the order of nature. These two provisions, unnatural, you know, sexual acts against the order of nature between males and females, even people of the same sex, with animals, and that kind of thing. And also sex between, as I told you earlier, people of the same sex. These two sections in the Penal Code prohibit that. So you could say that those provisions exist under Article 12(1) of the Constitution, the right to the equal protection of the law. So if this type of gender identity is to be tolerated, ultimately these provisions in the Penal Code also will be done away with. So then, now the parents, they are living their lives, rest assured that their children are protected, basically due to provisions like this. So the Supreme Court specifically referred to this Article 12(1) and these two provisions in the Penal Code and stressed the point I just now made and said that this should not be allowed. Then also it violates Article 9 of the Constitution. Article 9 of the Constitution is that the state must foster and protect the Buddha Sasana. Now, this Gender Equality Bill says that its provisions supersede all other laws. So then what about the laws that are in place to protect the Buddha Sasana? You know, the prelates, the Mahanayakas and the senior priests, you know, they also depend on various laws and regulations to maintain the Vinaya in the Buddhist temples and to do the activities to promote and foster the Buddha Sasana. Now, if there are laws in an act of this nature, bill of this nature, and if it becomes law, it's an act of this nature, if there are laws, those laws will directly challenge the laws these Mahanayakas and the Buddhist priests that are relevant to the Buddha Sasana. They will be challenged. Now, for example, I can give you an example is, you know, a person who is a transgender may want to get involved in some entity, you know, that has to do with the, you know, activities of the Buddha Sasana in a temple or temples or whatever. A transgender might want to work there. So the Mahanayakas, they can't prevent that because this law supersedes the other laws. So then the Supreme Court has directly referred to that also, that danger also, and said this is counter it is not conducive to the protection and fostering of the Buddha Sasana, and since the government is duty bound to do that as Article 9, this bill, the provisions, the particular provisions pertaining to that danger in this bill should not be allowed. So, based on these things, the Supreme Court has determined that if it is to become law, that the procedure in the Constitution set out in Articles 83 and or 84, read with Article 80 of the Constitution, that procedure will have to be adopted to, that is, you will have to go for a referendum. You will have to get a 2/3 majority in Parliament and subsequently go for a referendum where the people will have to endorse this.
Exactly. I think we have to get to the specifics on the determination as well. But before we do, when tackling this bill, there's a lot of other nuances that we have to consider as well. But to consider exactly how this bill came to be as it is in the current day, could you walk us through a little bit of what exactly shaped the key areas of this bill?
Actually, no, I believe not the players in our society, the people in our society, the members of our society, they are not the people who are behind bills of this nature. Now, I'll give you an example that is out of this topic. You take the case of diabetes. Earlier, the threshold was, if I remember, 160 or something like that for diabetes. Then the WHO brought it down to 120. Then overnight, quarter of the world became diabetics. Then later on, they brought it down from 120 to 100. Then half the world became diabetics. Right? Now, who is doing this? Who is acting as per the advice of the doctors and who are there? And these doctors, they happen to be stakeholders in the pharmaceutical companies also. That is very well known. So as a result of all this today, in the guise of diabetes, people are getting drugged to death. This is something like this. The first step is legalize homosexuality. One thing will lead to another. That will lead to same-sex marriages. That will lead to transgender. Because one partner will say, I prefer to be the wife in this arrangement. Then transgender. Transgender is surgical operations. Now the pharmaceutical companies come in a big way. After the transgender, drugs for life. So the health of these people and society degenerates while the pharmaceutical companies flourish. Here also it is the same thing. Because no homosexual, even a homosexual father, will not want that fate to befall his son, I'm sure. So the promoters of this kind of bill are not people of this country, the members of the society or any aggrieved party. Behind all this, the pharmaceutical companies working through the NGOs. They are doing this. So you must understand that and reject this type of thing. Actually, that is happening now. Now in countries like the US and all that, parents are coming out in a big way against transgender, the same-sex marriages. And they are not sending through fear. Now I told you earlier, now there are two provisions in the penal code. Parents are depending on that for the safety of their children. They are getting about their ordinary lives. Rest assured that their children will not be harmed. So like that, now those things have been removed in those countries. Now the parents are coming out in strength and protesting. What they do is, children in their formative years in these countries, they are brainwashed by plays, interesting books and all that, to act the role, if in the case of a girl, to act the role of a boy. Then suddenly that girl becomes accustomed to that kind of thing. And she is given a boy's name also. Then when she goes home, she'll like to be called by that boy's name. Then when she is nearing puberty, she will say that she wants to change her sex, the girl will tell. And with the, you know, unacceptable children's, so-called purported children's, you know, protection and children's rights and such laws, even the parents don't have much say. Then they will, now, when they say that they want to change their sex, what is the next step? Puberty inhibiting drugs are administered to stop the growth of the breast and so on and so forth. So we can see the harm that has befallen those societies, and the people are protesting. Now it has gone beyond the point of, now it's at the point of no return. So do we want our society also to the same fate to happen here, knowingly? So that is why the Supreme Court had determined that this is against the Constitution.
Unconstitutional.
Yeah, unconstitutional, and that the procedure I elaborated earlier will have to be adopted. If they want to go ahead with this, they'll have to change the Constitution. And in fact, the Supreme Court had even commented that even that should not be done.
Exactly. I think we have to get to the specifics on what the Supreme Court has mentioned in relation to the bill as well. But before we get into the specifics, we also have to talk about the general public's reaction to this bill and how it has been taken. Is it taken in stride? Is there opposition? Before we speak about any of the specifics on the determination and also on the public opinion, let's go in for a very short commercial break. You're watching Law, Land and Liberty. We'll be right back.
Sri Lanka Law College. My question is on the current context, what is the impact of the recent Supreme Court determination on this bill?
Welcome back to Law, Land and Liberty. We're in discussion with Major Charitha Siriwardene, attorney at law. We were just talking about the gender equality bill. Sir, thank you very much once again. We had a very insightful first segment where we spoke about the overview of the gender equality bill and what the current context is. I think now, before we go into any of the other future implications, I feel like we need to talk about the specifics of the actual determination that was just put out very recently. If we could have you walk us through one of the key areas of these determination and how exactly this translates into the future of this bill.
Yeah, sure. Now actually, now the determination becomes very interesting in the context of the Penal Code Amendment Bill that the government proposes to make into law. The determination regarding this was given some months back. They are, as per this bill, they want to do away with two important provisions in the penal code. If I may read it out so that the general public will have a idea, because now this bill I am talking about, the Penal Code Amendment Bill, the people don't know that the government is proposing to do away with these two sections. Before I came here, I made some inquiries. People were shocked that the government is planning to do away with these two sections in the Penal Code. People were in fact asking whether there aren't any other important matters that need priority rather than do this, you know, unwanted thing. So I will read out this section in the Penal Code. The section 365A, this has been slightly amended in the 1995 amendment. But the crux of the matter is, any male person who in public or private, I beg your pardon, section 365, whoever voluntarily has carnal intercourse against the order of nature with any man, woman or animal shall be punished with imprisonment. Blah, blah, blah. It goes on like that. That is, this provides carnal intercourse against the order of nature. Now, this has been slightly amended in the 1995 amendment. It's here with me. So, now they want to do away with this particular section. Now, this particular section tells carnal intercourse against the order of nature cannot be done. That is, even between a man and a woman, or even a married couple, against the order of nature. They want to remove this section because they want homosexuality to spread in places where people of the same sex are housed together. They want to spread it to those places, which is very, very unhealthy. For example, school hostels, men's hostels, girls' hostels, nunneries, monasteries, even the Buddhist temples, where the monks are housed together throughout the day and night. So that is why they want to make this illegal. There is no other reason. That is very clear. So in this determination, and these people, they are depending on the proponents of this. They are saying that the Constitution allows this. For example, they are quoting the preamble to the 1978 Constitution. I'll read a part of it. The latter part says, "We, the freely elected representatives of the people of Sri Lanka, in pursuance of such mandate, humbly acknowledging our obligations to our people and gratefully remembering their heroic and unremitting struggle to regain and preserve their rights and privileges so that the dignity and freedom of the individual may be assured, just social, economic and cultural order attained," so on and so forth. Now, they are depending on this word dignity. Now, they are saying this Swasti allows for homosexual, transgender, that, lesbian, that kind of dignity. Now, this is the 1978 Constitution. Now, these provisions are there from a very, very long time prior to that. Now, if the framers of this Constitution, envisaged to maintain the dignity of the homosexual and transgender lesbian type of dignity, if they wanted that upheld, then would the connected article 12 here that prohibits discrimination, would it be worded in the present fashion? Article 12.2 is worded like this: "No citizen shall be discriminated against on the grounds of race, religion, language, caste, sex, political opinion, place of birth, or any one of such grounds." Now, then sex is one thing, sexual orientation is something else. Then they would have definitely included sex, gender identity, and/or sexual orientation. So the framers of this Constitution deliberately omitted that, because they never wanted, gender equality or sexual orientation, allowing that to be part and parcel of our law. That is very clear. In fact, in this determination on gender equality, that is mentioned by their lordship, the relevant judges. I can show that part of the determination, in this determination they have said the judge, His Lordship Preeti Padman Surasena, I have already mentioned above that our constitution, now mind you, this is the latest judgment, determination rather, given a few days ago. I have already mentioned above that our constitution does not recognize the presence of gender equality. And there's only two aspects to the human being, male or female, nothing in between, nothing beyond. The constitution only recognizes that no person can be discriminated on the basis of sex. That means male or female, that's it. The framers of the constitution, in their wisdom, has deliberately left out recognizing gender equality. That means sexual orientation. Now, and the proponents, those who are advocating homosexuality, they are, citing examples of, European countries and all that. And in most of these countries, in their constitutions, in addition to sex, they have introduced sexual orientation to facilitate that. But here it's not there. So it's crystal clear. Homosexuality is taboo. In the determination, they have stressed that, explained that, highlighted that, explained that. That is taboo. So that is that. Then also, the advocates of this homosexuality, they are talking about. In fact, in this in the determination, early determination that has said that the ban against homosexuality may be removed. Their lordships have said, since it's assuming that it's a thing done in private. But the problem is, though anyway it's happening in private, as I told you, even sexual acts against the order of nature is happening between, married couples also, behind closed doors in private. So now homosexuality, those acts also definitely happening in private. But the thing is, once these provisions are removed and the floodgate is open, homosexuality is a very peculiar thing. There is something very intrinsic to that. Characteristic of that is that will invariably spread to the public sphere. That cannot be controlled. It will no longer be a private affair. Once the provisions are annulled, the provisions are annulled apparently because saying that it is a private affair. But once it's removed, it will invariably spread in the hostels, among school children, ladies' hostels, monasteries, temples, and society will be turned inside out for the worse. So now when you look at it in this context, what happens to our morality? What happens to our morality? Now, the government or the legislature is bound to uphold or to always do everything to improve the morality of the people of this country. Now that takes us to Article 27(1) of the Constitution. I will just read it out for the people's, for the information, knowledge of the public. Now here under Chapter 6 in the Constitution, There are the directive principles of state policy and fundamental duties. This is not justiciable. I mean, you can't go to a court and say that the government has not adhered to this. It's not justiciable. But the legislature is expected to follow what is laid down here. There are criteria laid down here to improve society, the morals, the economy, all that. So here, under Article 27 to 2H, this directive principle states raising the moral and cultural standards of the people and ensuring the full development of human personnel. Now, once these provisions in the penal code are removed and homosexuality starts spreading, as I told you, publicly amongst the people, as I had demonstrated and I have told you, how can that raise the moral and moral standards of the people? In this determination, the second determination against the gender equality bill, their lordships have stressed that also. I will read out that part of the determination. Thus, it is clear that those directive principles of state policy shall guide Parliament, the President and the Cabinet of Ministers in the enactment of laws and governance of Sri Lanka. It is important to understand that the establishment of a just and free society must be achieved within the framework of these directive principles, of which one is raising the moral and cultural standards of the people. The legislature is bound to act as per these directive principles. Now, when they bring amendments of this nature, how can that be achieved? And how can morality be raised? By encouraging, raising the barriers to abnormal behavior.
Exactly. We have to, unfortunately, I'll have to stop you there for a moment, as since time has run against us in this segment. We still have to continue the dissection of the decision given by the Supreme Court and also get into the specifics and the other key areas that were highlighted into why this gender equality bill was unconstitutional and also the public's view on it as well. Before we get into any of those specifics, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back.
Hello, my name is Dhanuji Veeragon and I am a grade 10 student. My question today is on the future implications. How will the progress of this bill change following the current situation?
Welcome back to Law, Land and Liberty, where in our final segment we were discussing the intricacies of the Gender Equality Bill with Major Charitha Siriwardene, attorney at law. We just embarked on two very packed topics, segments where we saw the breakdown of the Gender Equality Bill, and we were just, unfortunately, so I had to cut you off in the middle previously, relating to the specifics in the determination. If we could carry on where we left off.
Yeah, sure. Now, I earlier mentioned abnormal behavior. Now, even in this determination, I could say against the Gender Equality Bill, their lordships have said like this. This is pertaining to the fact that laws, if enacted in this bill, will directly, make subordinate laws that are for the fostering and the protection of the Buddha Sasana. So that cannot be allowed, because it will be a violation of Article 9. Now, to explain that, in the determination, it is said like this: to direct a religious institution to appoint as a server a person who claims and is known to be a lesbian. Mind you, this is the determination of the Supreme Court. I repeat, to direct a religious institution to appoint as a server a person who claims and is known to be a lesbian, gay, bisexual, transgender, or any other person who is inclined in any abnormal sexual practices. Now, I was talking about morality. The government is duty bound as per the directive principles which I showed earlier, as per the directive principles, to enhance morality. Now, by removing these sections in the penal code that give way for homosexual behavior to be legal, right? So, now homosexual behavior has been explained in this judgment as abnormal sexual practices against the order of nature, religions, morality, and culture of the people of this country. In other words, what the determination says is, lesbian, gay, bisexual, transgender, or any other person who is inclined in any abnormal sexual practices against the order of nature, religions, morality, and culture of the people, those acts are against the order of nature, religions, morality, and culture of the people of this country. In this latest determination, they say that, and the proponents of the bill to amend the penal code, they are talking about privacy, and privacy is not guaranteed in our constitution. Privacy is not guaranteed in our constitution. That is also mentioned in this judgment.
So there is a comprehensive understanding of exactly why it is unconstitutional.
Yeah. Just give me a moment. In the determination SC/SD number 54 of 2024, in the determination it says, His Lordship says, however, I note that there is no such right as right to respect for one's private and family life or one's home and correspondence found in our law. Moreover, I note that the right to private and family life is found only in this bill and not in our constitution. So that is also one reason the determination is against, is more or less against the bill. And also, as I demonstrated, homosexuality, if these acts are allowed to continue, catch up in public through the hostels and temples, monasteries, it will affect not only Buddhism, other religions as well. So then that directly impinges on Article 9. The government, the state is bound to foster and protect Buddha Sasana, so they should not allow this amendment. Then also these proponents of the amendment to the penal code, then they again, let me tell you, in the Swasti, they are quoting the Swasti and saying the dignity mentioned there, the word dignity implies, homosexual, transgender, lesbian, that kind of dignity. If it could be interpreted that way, then it could even be interpreted that they are allowing, nude colonies and that kind of thing. Now, if the word dignity in the context of the Swasti, if they are imagining that allows for homosexuality, then that should allow for same-sex marriage. I'm talking about the Penal Code Amendment bill. Then that should allow even for, marriage between same-sex marriages, transgender, nude colonies, all that. And these people, they are taking the example of India. That is the last place from where we should, sort of have an analogy. India. Because India's, religious and India's, the sexual and other even religious practices are very much different from us. In India, in the olden days, there were religions, even still those religions are there, and they resort to those practices. You know, those people walk naked on the roads. And even to the present day, India has nude colonies. And India has red light areas. Now, those things are taboo to our culture. Taboo to our culture. So, our laws should be in accordance with our religion and culture. That is also stated in this determination.
Does that mean, sir, that the determination has appropriately touched on all areas in relation to this
exactly,
bill?
Exactly. You know, in the determination, in the latest determination against gender equality, and that it will have to be passed by a 2/3 majority and put to the people at a referendum, if they want to bring this about. In the determination, His Lordship says, when this bill becomes law, it becomes possible for any interested party to claim legal status for same-sex marriages through the definitions and provisions of this bill. This is something which neither our constitution nor our culture has envisaged. It goes for homosexuality also. Homosexuality is also very much criticized in this determination, as I showed you earlier. Neither our constitution nor our culture has envisaged. All the religions practiced in this country have not deviated from this culture, for both culture and religion is part and parcel of the practice of the people of this country. Practice of culture and religion in general cannot be contrary to law of the country. So we all know, you know, homosexuality is not part and parcel of our culture, nor the religions, not only Buddhism, other religions of this country. So if they are bringing laws, those laws have to be in accordance with the culture and religions of the people. So this Penal Code Amendment Bill is not so.
So the bill in itself is completely contradictory to the traditional and foundational bedrock of our society.
It is very much clearly explained in this determination, SC/SD number 54 of 2024. Now let's go back to the first determination.
Actually, sir, I'd like to just temporarily stop you there to ask a question of curiosity. According to your knowledge and your opinion, how has the public been reacting to this?
The public, right, you come to a good stage. Now, as I told you, the first determination about the Penal Code Amendment Bill, their lordships have rightly said, though they say it is not against the Constitution, they have stressed the fact it is not for their lordship's court to say whether to go ahead with this or not. That is left to the government. Their lordships, I respectfully state, have rightfully said that. It is left to the legislature, government and legislature. That is a very important point. The legislative power has been entrusted to Parliament. That legislative power is the people's legislative power. And it is to be held in trust by Parliament. So when they are enacting laws, they will have to do it as per public opinion, aspirations of the people. That is what their lordships say, even in the first determination. But in the second determination, it is very, very well explained why this type of behavior attributed to gender identity should not be made law in this country. Now, I'll give you another example. In the context of the first determination, that has said it's not against the Constitution. Now, just because a thing is not against the Constitution, the legislature can't pass that. So, there are so many things that's adverse to the people that may be not
they have to consider.
adverse to the people, unhealthy, things that are not good for the people, that may be possible under the Constitution. Because the framers of the Constitution at that stage cannot think of everything. So that is understood. A good example is, now when we are reading for a law degree, it is said that a common example is the British Parliament. British Parliament is not like our Parliament. They are sovereign. They can pass any law they want. For example, if they want, they can pass a law saying that all blue-eyed babies should be killed. So, but will they do that? They won't do that because public opinion is against it. Now, so what I'm trying to stress is, even though there is a determination that the Penal Code Amendment Bill is not against the Constitution, that does not give the right to the legislature to bring that about without consulting the people. Now, as I told you, since this impinges, on Buddhism, on the protection of children, their future, the concerns of the parents, the public, and all that, the government is duty bound to initiate a public debate on this matter, homosexuality matter. Unfortunately, sir, our time has run out, but I believe that is an adequate point for us to leave off this discussion on just because it is unconstitutional, just because it has been considered constitutionally acceptable does not mean that it will necessarily be in the best interest of the public. And there's a lot of intricacies in relating to the bill, and also probably a very lengthy process in reconstructing, if at all this happens in the near future. Thank you very much, sir, for taking the time to educate the public relating to, and our viewers relating to this topic. I believe it was a timely discussion. Thank you once again, sir. Thank you very much for giving me this opportunity to put these facts to the public, which they should certainly know. All right, well, equality is a word that's often thrown around, disregarding the true weight of its meaning. And we as citizens of Sri Lanka have an obligation to ensure that democracy is not abandoned in the pursuit for a level playing field. We leave you tonight with the words of Thurgood Marshall, former Associate Justice of the Supreme Court of the United States. Where you see wrong or inequality or injustice, speak out, because this is your country, this is your democracy. Make it, protect it, and pass it on. That's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/Derana English. Thank you very much for watching. Have a good night.